All right then. Good evening, everyone. Thank you for joining us tonight. My name's Margaret Buchanan, and I work at PA in the Industrial Strategy and Workplace Advice and Support team. And I'm here tonight with Leon Yap, who's our Honorary President of the Pharmacists Division. We're going to talk about non-compete clauses and other restraints on employees post-employment tonight. I need to make the usual disclaimers that please don't take this as legal advice. If you need legal advice, to seek that separately. Tonight is more aimed at providing information of a general nature. And the reason we are focusing on this is because there is a government inquiry underway at the moment that provides an opportunity to for the community at large to contribute to what happens with these clauses. It's unusual for us to be able to make changes to the contract of employment itself. It's a creature of common law. Governments don't tend to put much around it, apart from things that you have seen, such as pay secrecy being abolished and so on. And this is a really important step that's happening at the moment. So what our purpose tonight is to raise awareness of the types and effects of these clauses. And they can be found both in the employment contract itself, or you might find that you've signed a contract and you're asked to sign a separate agreement that sets out the restraints. And the other part of this evening is to talk about the government inquiry and participating in that. So we'll start off by talking about what is a non-compete clause. They're also often referred to as restraint of trade clauses, but restraint of trade clauses usually aimed at businesses. So a non-compete clause is a clause that prohibits you from working with a competitor or starting a competing business of your own. The reality is, as employees, that can mean that you're limited from actually working in the industry in which you've developed your knowledge through your work. So that can have a very limiting effect. Typically, a non-compete clause operates for a limited time period and/or for a competing business, and/or for a limited geographic area. A very simple example of a non-compete clause is one that we came across in pharmacy, and it reads along the lines of: the employee agrees that for 24 months after cessation of this agreement with the employer, she will not directly or indirectly participate, assist, or be interested in, whether as a sole operator, partner, associate, consultant, employee, independent contractor, employer, or in any other capacity, or be employed in a business whose products and/or services compete with the employer within a 3K radius of, and this is a very large chain of pharmacies. So it would have a major impact on employees. But I'll just go to another one to give you in a kind of a more a type of clause that is more likely to stand up if it is being relied upon to be enforced. And you'll see that what it talks about is in consideration of the remuneration paid to you during your employment, and to protect the company's legitimate business interests, it asserts, you agree that without the prior written consent of the company, you will not, whether directly or indirectly during your employment or during the restraint period, and then that's set out in another part of the contract, which can be 12 months, 9 months, 6 months, or 3 months, be involved with any businesses competing with the company as a principal agent, all those different categories again, in the restraint area, which can be Australia, Australian states, Victoria and Queensland. Now, we'll just talk a little bit about this clause, even though it is quite turgid. And Leon had said to me, do we really have to have something so technical? These clauses tend to be technical, particularly the ones that an employer may seek to enforce at a later date. The first thing that you probably noticed is these different periods of time and different geographic areas. So it starts off 12 months, with 3 months being the minimum, starts off Australia, ends up being Victoria and Queensland. So at common law, there's a bit of an all or nothing approach with contracts. Clauses are either void or valid. And one way of trying to avoid that problem of the whole clause being struck out is to have smaller periods of time and smaller geographic areas that the non-compete applies for. It could mean, for example, if this were taken to a court and it was being sought to be enforced and the court was satisfied of various tests, and we'll come to them a bit later, that it may in fact be a non-compete that only applies for 3 months and in Victoria and Queensland. But if that Victoria or Queensland were where you were wanting to go and work at another employer, it would have the effect that you may not be able to commence employment as you had agreed with your new employer. So it can have dire impacts. The other thing you will notice is that they do word this in a way where they are conjuring up that this restraint is to protect legitimate business interests. And one of the things that courts look at is, because I think most people here will be aware that non-compete clauses, as a general rule, are not enforceable. The exception is where it is to protect a legitimate business interest. And the argument that typically employers run is that the only way we can ensure that all our confidential information and all our clients are not hived off with this employee is that they can't compete for a period of time. That's, as I've said, we'll come to that a bit later as to how the court looks at those sorts of questions. Generally, though, the issue for members when they're looking at clauses such as this in their contracts is, well, if this is a deal breaker for me, will the employer change the clause? And we're increasingly finding that members are reluctant to make the job dependent on whether or not the employer will take out the clause. They'll hope that it won't become an issue, but we'll talk a little bit more about that down the track as well in the course of this evening. So I'm just going to talk about the other sorts of limitations post-employment with an employer that will also appear in contracts, because the inquiry also touches on these issues as well. And one is the confidentiality clauses, and they aim to prevent you from disclosing confidential information about your former employer and their business. And the other is the anti-poaching or the non-solicitation clauses that aim to prevent you from soliciting clients or employees of a former employer to go with you to the new employer. I thought you might find it of interest that about the confidentiality, because under the Corporations Act, there is already provisions that protect employers from employees or others, can be directors, for example, from disclosing information that will either gain an advantage for themselves or for someone else or cause detriment to a corporation. So that post-employment can be an offence under the Corporations Act. And often we see it's confidential information that's tied up with the non-compete clauses. So it is important, I think, to understand that getting rid of non-compete clauses, which I think personally would be a great thing from the landscape, won't necessarily lead to employees being able to disclose confidential information. Now, what is confidential information? One of the things it isn't is know-how. And often what is sought to be protected, in one example that I'll tell you a bit more about later, what they were really arguing is that they wanted to use the non-compete clause to protect the know-how information. Now, that's not protectable through confidential information. The other thing about confidential information, it's not property. So it's not as if the company owns it as such. They have to, in order to enforce confidentiality clauses, be able to identify, well, what's commercially valuable about this information that they need to protect. And what they really need to do if they want to protect it is take steps to protect it, to give it the quality of confidentiality. So you'll know that you're dealing with confidential information in your employment because the employer is restricting its circulation, even within employees. It will be informing employees who have access to it that it is confidential information. So taking those steps becomes necessary for an employer that wants to rely on that. So as you can see, it puts a bit more of an onus on the employer to be very clear about what is confidential information if they want to protect that aspect. So we'll just move on to the next slide, which gives an example of a non-disclosure clause. So even without a contract, and even if there weren't the Corporations Act as well that protects confidential information, traditionally common law has protected the confidential information that an employee picks up through their employment from indiscriminate disclosure or disclosure that is to their own benefit and to the detriment of their former employer. And this is the sort of thing that will be in there, is that is protected forever. It only ceases to be protected once it is in the public domain. Once it's in the public domain, it's no longer confidential information. That's fairly clear. And it can enter into the public domain in all sorts of ways. It could be through media reports, it could be through court decisions, it could even be disclosure through government reporting requirements. All of these sorts of things are ways that company confidential information can end up in the public domain. But as you'll see, clauses of this type, and we've seen them develop significantly in the last decade as well, that a company may still be seeking to rely on legal action to restrain you. I'll just move on to the next one while we're talking about examples. I've picked this example because I think it goes too far. I think it's one thing to have a non-solicitation clause that says you are prohibited for, let's say, 6 months after you've worked somewhere from inducing other employees or clients of the company to come to where you are working. But as you can see, this covers canvass, induce, encourage, solicit, or attempt to canvass, induce, encourage, solicit any employee or contractor to leave the employment or engagement of the company. And similarly with the clients, all those words. And so I was talking to a member today about this kind of clause, and their comment was, look, I could be asked to sit on an interview panel. I haven't taken any part in inducing the employee from my old company to come over. But my mere sitting on a interview panel potentially could be covered by clauses that are so wide-reaching. And that when they are wide-reaching, that does make them problematic for enforcing them at a later date for the company. So that is something to bear in mind. So I just wanted to run through what are these clauses that we're talking about. Probably many people that are here tonight are on contracts with clauses like this, or have seen clauses like this in previously. So in terms of who is expected to enter into these restraints, the current government inquiry actually quotes some research that suggests around 1 in 5 Australian workers, that's total, are subject to a non-compete clause. Our contract review service, where we review contracts for members, is that we are seeing around 1 in 3 members who are seeking contract reviews having non-compete clauses in their contracts. And I'm just mentioning here, nearly all contracts will include a restraint on disclosure of confidential information post-employment. And the significant thing about that number 1 in 3 is that, of course, we also have a significant number of members who are on enterprise agreements. Enterprise agreements, you don't see these clauses. These are things that are creatures of common law and under contracts. And so this problem doesn't exist where enterprise agreements exist. But the problem we are seeing with enterprise agreements, and this could be, you know, the subject of a totally different webinar, so we won't get into it too much tonight, is that the scope and the coverage of enterprise agreements in the Australian workforce is shrinking. And that's part of the reason why the government has created the Secure Jobs, Better Pay and other legislation to try to address that. But as enterprise agreements become less predominant, contracts become much more what is setting the standards for Australian workers generally. So 1 in 5 is a scary number, I would suggest. And it becomes also concerning when you see that this is not limited to highly paid professional workers. It's very common in the hairdressing sector. The concern is they use the non-compete to stop clients from moving. They could just be having a non-solicitation clause. Gym instructors, same issue, and childcare workers. And interestingly, there's a report at the moment of a decision just in the last week of a hairdresser who was went to start their own business. They put on social media, that's what they were doing. And they received a letter from a law firm saying that, you know, this is a breach of your contract. Our client, being the former employer, expects losses of something like $300,000 as a result of their clients moving across to you. This is like a single operator, bear in mind. And fortunately, she was able to get legal advice, and accessibility to legal advice is a big issue, of course, with all of this and the costs involved, and we'll come to that. It reduced the amount to $90,000, and it did go to court as well, and the court threw it out. They said, this is ridiculous. This person was a casual hairdresser in a beauty salon that a business is trying to restrain from starting her own business. That is completely not what should be happening. So that was a refreshing intervention into this debate at the moment. But I would just say, I don't think we can rely on courts to always find that result. And we'll talk more about that as well, because there's a very interesting article that the government inquiry has set out about what is, that's based on interviews with legal practitioners that specialise in this area, about what are the things that happen with restraint of trade clauses. So that brings us to one of the most common questions that was asked in the lead up to the webinar tonight, and that was about whether or not non-compete clauses are enforceable. And the reason I start off by saying they can be is because I think a lot of people think they're not. The real difficulty with them is that when you enter into a contract of employment with a new employer that you may not know that much about, and you go and work there, what you don't know, if the clause is well drafted, that's the first bit of defence the employer has put in place. Then it will depend very much on the nature of the employment you're undertaking, but also it comes down to personality issues. The example that I had recently where we assisted a member was someone was working with a new company that was, more would mean that they would be able to get a promotion, came onto the scene and they took a job there. They received a letter from one of the major law firms in Australia saying, you're breaching your contract, the non-compete clause, and also raise confidential information issues. As you'll see, they're nearly always inextricably linked, because it's that establishes the legitimate business interest for the company. The person concerned was completely alarmed to be getting a very tersely worded, long, detailed letter from a law firm saying that if you don't agree to do this, which is not start employment, our client will consider what further action they can take. In other words, they are considering taking legal action against you and being faced in court. Now, the person in that situation, the advice that I had to give them was that if, more often than not, what happens with matters like this, if they do go to court, is initially all that's being sought is what's called an interlocutory action. Sorry for the big words, where they seek an injunction. The importance of that is that it's not a full trial. It's a preliminary step, and the tests that the court need to be satisfied are on the balance of convenience. And generally, the balance of convenience when it comes to matters like this sits with the employer. It's the employer the former employer that's asserting that detriment will occur if action's not taken. So an injunction that could be an injunction, a court order that says you're not to commence employment as per the contract that you've entered into, can be the outcome. It's not the only possible thing that can happen. The courts can also determine that, look, we'll accept undertakings from this person. Now, this all comes down to your legal representation. And one of the things that I think we don't make too much of when we're talking to members about entering into contracts with restraint of trades in them, because you really don't know at the time you're entering into it whether it's going to be an issue or not. It only becomes an issue at the time when you're looking at well down the track and looking at other employment and possibly having even accepted other employment. I just want to kind of go through a couple of things with you about, so the uncertainty. When it goes to the court, even at that interlocutory stage, the court needs to make several assessments. One is, does the employer have a legitimate interest? How the employee threatens that interest, whether the interest needs immediate protection, whether the protection needs to go so far, and whether the detriment to the employee and the public interest is too great. But they don't look at what was the negotiating power at the time the contract was entered into. They don't look at the fact that the employee didn't really have the ability to negotiate that contract. It is assumed, and often you'll see contracts will reinforce this, that the employer's got independent advice, they agree the restraints are reasonable, and they will accept it. And that asymmetry is not the issue that courts may be reluctant to impose. It is the threat to the freedom of trade that is what they are looking at with these clauses. And they are willing to protect a legitimate business interest. Now, in the case that, the recent case that I was assisting the member with, it was actually difficult to see what was the legitimate business interest. It did seem like that could be challenged in this instance. And we sought additional advice from one of the law firms that we go to when we need to get specialist advice on matters. But you can never give a definitive answer. And this is one of the real problems in this area, is that as an employee, if you are looking at, look, I'm going to push this a bit further, you could in fact find yourself with being faced with papers, court papers saying, turn up, the proceedings are happening, and they happen very quickly, for that interlocutory injunction potentially. There also, as the slide indicates, courts generally view upholding contracts as being in the public interest. Now, there may be other public interests that can be argued, but as you're starting to get the sense of, this is a complex sort of area. Employers will generally have deep pockets. And I mentioned about personalities. So it did seem in the particular instance that while the former employer was certainly considering their options, they weren't necessarily of a litigious nature. But there can be firms and those who are making the decisions with them that are of a more litigious nature. There can be also where there's a bit of a grudge about the new firm, the new company that they're seeking to, you know, they don't want them to get the benefit of that employee, and prepared to throw some money at it. One of the things for an employee, and this is also starting to show up, and it was this that's really started to make me feel quite concerned over the last 12 months, is we're starting to see clauses in contracts that not only do they have non-compete clauses in them, but they're asking if you are free to enter into a contract and whether you can warrant that there is no limitations or restrictions on you from entering into a contract. So some employers are already making the decision, we don't want to get caught up in this sort of stuff. We want to know that employees who come and work with us are warrant that they are free and have no limitations on them coming to work for them. So that then starts to make it difficult for employees to kind of play the way that we may have played, which is that, look, I'll enter into this contract. They don't tend to enforce these things anyway, and I'll take that gamble. Now we're starting to see when you go to new employers, they're asking you, have you got one of these clauses from your own employer? And then there's a real issue if you say that you don't and you do. That can be the sort of thing that breaks the trust and confidence of the new employer in you and can have impacts. I don't want to exaggerate this because we actually know that most matters don't end up in court. Very few do. In some ways, that creates a bit of a problem because we don't have very clear law. The law itself is pretty unclear. But on the other hand, a lot of stuff is sorted out at a compromise level. So with the member that I was talking to you about before, it was agreed that certain undertakings would be given about the confidential information that they had. And that was easy to give because really all that was about was they'd had sent some of their work emails to a personal email and they agreed to destroy that, and that was the end of it. So that was pretty easy to agree to. But that's another thing that happens when these issues are going on, is that the employer who's got access to all the IT systems and all the rest will go through all your records to see what have you got. Have you maintained the policies that you've said you would? The situation in New South Wales is worth mentioning because there is specific legislation there. There is a view amongst legal practitioners that restraints of trade are more easily enforced in New South Wales, partly because of legislation. Partly also, though, there's a much greater number of restraint of trade enforcement activity that goes on in New South Wales. So that can have that effect. The article that I mentioned, and the citation is on the government inquiry site, it actually talks about that non-compete clauses are not necessarily overly enforced, but they're overly observed, meaning that most employees, when they're given a letter, don't have access to legal advice, will probably just say, yeah, okay, I won't go and do that. So we'll just move on. So these are just some observations about what we're seeing arising from these clauses. Look, there is a belief that only people who are highly paid have them. We're not seeing that. The most extraordinary one we saw was a graduate engineer had a restraint non-compete clause. As I've already touched on, there is a significant power imbalance in many employment contract negotiations. Look, there are members who say no, and they're prepared for it to be a deal breaker. They're usually in a situation where they're in employment, relatively happy in that employment, and so their negotiating position is pretty strong. But for those who really are, they're looking for a job, they may need to get out of where they are, things aren't great where they are, and they sign up to this sort of thing. Really, we try to assist by sort of being very clear about what these clauses might mean for them. There's a belief, and this is not so much amongst members, but more generally in the community, that employees who have these types of clauses are paid extra. Now, something I used to see, but I don't see anymore, is that there might have been a longer period of notice in these types of clauses. I just don't see that these days. And in any case, I think the thing is that if you've got a restraint, and generally there's a general view that around 6 months is not unreasonable. Unless you're getting income during that period, that can really put people in a dire position. And also you may enter into a contract, be on a probation, and be terminated during that period, and you're still stuck with that restraint. Not all restraints these days even include the ability that the one that we did look at provided for, where you might get prior written agreement. And so on that basis, you could go to the employer and say, look, I need to find some other work. This is where I'm thinking of going. Do you have any issues? And they might agree, yeah, look, that's fine. And again, anecdotally, that does occur. Sorry, I just need to go back. I've touched on already the widespread feeling and this issue about the warranty, that you don't have a non-compete clause in your old contract. So that is just a bit of a snapshot of what our experience is with restraints and non-compete clauses generally. And I'm going to hand over to Leon now, who's going to talk a bit about the government inquiry and its significance.
Sorry, technical issues as per usual, trying to find the mute button. So thank you, Margaret. Yeah, so as there is a government inquiry going on, and the Australian Competition Review is undertaking this inquiry following a Treasury white paper, which showed that the white paper last year showed that these clauses are becoming a major impediment to a stronger economy. They're becoming a lot more prevalent. I think it's upwards of 20% of all employees are subject to one or more of these types of clauses. So, but there's been a historical debate of why these clauses are necessary. I guess with perceived benefits and issues on both sides of the equation. I guess the pros of these types of clauses are that workers and the firms, the employees benefit by incentivizing investment, whether that be in the business itself and the products that they make or sell, but also it might incentivize the employer to invest in the training of the staff, so to improve their knowledge and skills, which can have mutual benefits on both sides. But I guess the cons of these types of clauses, as we've seen, can reduce competition with that between firms for staff, or just competition in general. Reduces the mobility of workers, so the ability of workers to move from one company to another. Reduces entrepreneurship. Wages growth is stunted, and innovation, and there's also reduced productivity growth in the economy. Next slide, please. Not sure if I have control. That's okay. I'll just keep going anyway. There's research. Some researchers argue that over the past decade, evidence is tilting towards the fact that these clauses are causing more harm than good. They're becoming indiscriminate in their use. So as we said, it's upwards of 20% of the workforce, whether that be high wage earners or people in low wage earning jobs. There's obviously little negotiation a lot of the time for these clauses, because as the power imbalance is there, a large corporation obviously can set employment expectations sometimes. In terms of its harm, they can harm workers and the firms, whether that be the firms trying to hire the right staff, or it could even mean that locks the wrong staff into a particular company who wants to actually move, and they feel that they can't because of these clauses. Reduces innovation, and it can affect consumers. So we're talking things like limiting competition here between companies, but also could down the track lead to potentially higher prices or inferior products if competition is stifled. The evidence is that there are other tools that can protect businesses without these types of clauses. So we're talking things like, the example was given was the Corporations Act, and we're finding in PA's experience that this is happening in reality, with plenty of cases coming through our workplace support team showing that members are being affected by these clauses. So obviously there's a public interest in placing some controls on these types of clauses, and the government has a number of options that they can go down, a number of pathways. There's plenty of overseas evidence to show that, or not to show, but sorry, plenty of overseas examples of different strategies that can take place. So that can range from a total prohibition from these clauses, which is possibly where the US is heading. Quite recently, the Free Trade Commission has just recently banned the use of non-compete clauses in the US, although it is subject to some legal challenges in some of the states. But you know, that's a total ban, which I think is one option. There could be limits on the timeframes of non-compete clauses, such as the UK. They're proposing a restriction on the length of these clauses in contracts to, I think, 3 months. Or there could be, you know, a requirement for compensation to the workers during these periods of restraint if it is found that these types or some of these clauses are necessary. So your so-called gardening leave that you may hear from your top executives who get given 3 or 6 months gardening leave. I think that would be quite nice if if an employee was given that. And so yeah, so that's what the government is inquiring to do. Professionals Australia is proposing to make a submission. The government is calling for submissions from affected parties. And we are going to make a submission because we think workers should be able to move around quite freely, not be subject to these provisions, and, you know, benefit from, I think the evidence shows that worker mobility does help to increase wages. So we're obviously supportive of that. And your good employers will always keep their workers. If employers treat their staff correctly, you know, there's less incentive for you to move on somewhere else. The ACTU is proposing to support a total ban on these types of clauses. And I think the position from PA is that we think that I think we support this position, and our experience through the WAS area is that there is wide scale abuse of these clauses. So yeah, I guess as it says at the bottom, unless, you know, there is mandatory gardening leave, paid gardening leave that's offered in conjunction with these types of clauses, then they probably should be banned. So what can you do as a member? Well, if you want to learn more about the actual consultation itself, you can hit this website up here, Treasury website, and you can read the issues paper. If you have any particular experiences or examples, and you'd like those in our submission, so please forward those off to Margaret. That's her email address there. And there's a survey in the paper as well, if you want to sort of give some evidence or some experience directly to the government inquiry, and the website is there the link is there to do that. And yeah, that's it from me. Thank you everyone for coming. Does anybody have any actual specific questions they want to ask?
I can see there's one question in the there that asking what is the stand in the European Union with regard to prohibiting such clauses. I can't answer that question directly. I think there may be some prohibition, but the OECD generally has been looking at this, so we may in fact be able to update people with that in a post-webinar email, just what's happening across the OECD countries for your information about that. I can see there's a request to copy and paste the information. I'll try and do that.
And there's another question about, is there current estimates of when the consultation may result in any legislative change?
No. I was fairly surprised that this was happening in this first term of government at all. I would have expected that it would only start perhaps the next term if there was a second term. So we'll see what happens there. But their rate of legislative reform has been in this area, in industrial area, has been quite extraordinary, I think, so far. So they've certainly done a lot better than I thought any government could achieve. Now, hopefully that has worked. Yes. I need to make that to everybody. Has that come through? Because I've tried to copy and paste.
Oh, there we go. That's the.
Oh, good. Thanks, Leon.
Wait, sorry, I'll copy and paste this.
How about that, Adrian? Has that come through now? Leon's tried to do it as well. We've got limited options, hosts and panelists. Yeah. Look, we'll include the information in a follow-up email, I think, to cover that off. No issue about providing the slides to those who couldn't make it today.
I think that's a good idea to put on the PA Discord.
Yeah, we'll do that. Yes, it's extraordinary, isn't it, that this sort of thing, restraints are starting to occur in government sector as well. I agree with that comment, David. Peter, I think that's the million-dollar question. How can you determine who is a competitor to your employer, a company, if they are within the industry of that company? And that is really why, as well, I think the competition review is looking at this, is that it is anti-competition to limit where people can work for these sorts of reasons.
Comment here about a 19-year-old unqualified pharmacy assistant being asked to sign a contract with a 12-month constraint and a 10-kilometre radius. That's, I mean, that's outrageous. You know, a 19-year-old assistant is probably, you know, on less than $50,000 or less than $40,000, and you know, they've got no power in that workplace to say otherwise, which is just terrible.
Yeah. All right. Well, look, we will follow up following the this evening's webinar with a follow-up email with some additional information for everybody. Look, it's great everyone got on tonight and attended. I really appreciated having Leon here with me as well. Thank you, Leon. That was fantastic. We'll say good night and best wishes to you all.
Not everybody. Thank you. Thank you, Margaret.